So now let's take a look at the Section 2703 orders. And this, of course, is a court order. It's going to require more process than simply a subpoena, and we'll look in a moment at what kind of showing is required. So let's look first at the 2703 order without notice. So first, anything that can be obtained through a subpoena without notice. And then second, all records or other information pertaining to the subscriber that are held by the provider, not just the specific records that are referred to in the subpoena provision, but not including content information. So we're talking about record information here, not content information if you're proceeding without notice to the subscriber. What kind of showing has to be made, and that is here under 2703 D, and it indicates that the government has to show specific and articulable facts showing there are reasonable grounds to believe that the records are relevant and material to an ongoing criminal investigation. So this is a showing that is higher than a subpoena, but it's significantly lower than a search warrant. It's not probable cause, it's simply specific and articulable facts of relevance. Now, why have this intermediate provision? You can see this section of the legislative history that's reproduced in the CCIPS manual, and it's just imposing an intermediate standard, higher than a subpoena, lower than probable cause, and notice this statement of the intent, just to prevent sort of very broad fishing expeditions. In a sense, it's imposing a bit of a transaction cost, right? Some time and effort that has to be put in beyond simply sending out subpoenas, requiring the government to go to court. The theory is provide some disincentive to look overly broad. So what about the 2703 order with notice? So the 2703 order with notice allows the government to obtain everything associated with the account, including content information that is stored for 180 days or less, except for unopened emails or voicemails. All right, so this is content information, 180 days, even if it's 180 days or less. So why the exception for unopened email or voicemail? This is just reflecting the drafters of the statute, trying to balance out where there may be heightened expectations of privacy, either on behalf of the subscriber or on behalf of a third person, that might require other kinds of process on that third person. So if someone has sent an email and you've sent me an email and I haven't opened or read it yet, then it hasn't necessarily been disclosed yet to a third party, and the third party doctrine might not apply, and the same thing might refer to unopened voicemail. Okay, so notice the language of the statute. Contents of wire electronic communication that's been in electronic storage in an ECS for more than 180 days, or contents of a wire communication by a provider of an RCS, and that can include less than 180 days. So again, we have this distinction between the RCS and the ECS. So what does some of this mean as a practical matter? Remember that in the Ninth Circuit there is this case, it's the Theophil case, that has a much broader definition of what an ECS is as opposed to an RCS than in most other circuits. So remember that the provision we were just looking at makes this distinction between ECS and RCS with respect to information in storage less than 180 days that can be acquired through an order with notice. So outside of the Ninth Circuit, through an order with notice, generally you can obtain any subscriber information from an ISP, a cell phone provider, and so on, except unopened email and voicemail, because most other circuits are going to consider those providers as providers of RCS for everything except unopened email and voicemail. In the Ninth Circuit, those providers generally are going to be considered providers of ECS, and therefore, if it's less than 180 days old, you won't be able to obtain it even with a court order with notice. You'll have to serve a subpoena. And as we've noted, and as this section here notes, some providers even outside of the Ninth Circuit have resisted providing content information without a warrant because they're concerned that the Ninth Circuit's reasoning might be adopted elsewhere, and they also do business nationwide. So in many cases, as a practical matter, for content information less than 180 days old, absent having a fight with the provider, the government might have to get a warrant. Okay, so how about the warrant provision? So the warrant provision allows the investigators to basically get anything consistent with its sort of authority, warrant authority under the Fourth Amendment relating to the subscriber. The warrant requirement never requires the government to provide prior notice to the customer or subscriber. Search warrants are routinely issued ex parte. Obviously, why do we even care about all this notice? I mean, it should make intuitive sense. If you give notice to the suspect that their information is being, acquired from their provider, they may pack up and leave town and so on. They're going to be tipped off, right? So the search warrant, you never have to give notice. And you can obtain all of the contents, consistent with the full scope of the Fourth Amendment, even if it's 180 days or less, regardless of whether the provider is a provider of RCS or ECS. Now, I mentioned before that there are some differences between the search warrant provisions under 2703 and Federal Rule of Criminal Procedure 41, which we have already looked at, Rule 41. So here are some of the differences. The 2703 warrant can be issued for records held in another district. So ordinarily, a Rule 41 warrant can be issued for records within, and for a search within the district in which the warrant is issued. And if you want to do a search in a different district, you have to go to a court in that district and get that court to issue a different warrant or another warrant. So here, it can be a multi-district warrant, and this simply reflects the reality of sort of distributed network computing. It allows a broader initial scope of production. So recall from looking at Rule 41 that a search warrant has to be reasonably specific. You have to specify the kinds of materials that there is authority to seize. So if you were going to have a warrant that said, seize all emails relating to this account, period, full stop, that probably doesn't satisfy the Rule 41 standard. But under 2703, you're able to do that, or the government is able to do that. And then what the government has to do is review that information and identify which specific emails, for example, are within the scope of the subject matter of the warrant and retain those specific emails. But obviously this allows sort of a much bigger nose in the door, so to speak, than a Rule 41 warrant might otherwise allow. Okay, what about voluntary disclosure? So there are circumstances under which a holder of information may choose to voluntarily disclose it to the government, and in which that voluntary disclosure will not be a violation of any of the originator or subscriber's rights, and which will not be a violation of the ECPA or the Stored Communications Act. And the distinction here is whether the service provider services are available to the public or not available to the public. If the services are available to the public, as defined in the statute, then the restrictions of the Stored Communications Act apply, and either the subpoena or the 2703 order or a warrant is necessary. If it's not a provider of services to the public, then they can freely disclose if they want to. So why this distinction? This is really trying to get at, and the whole thing that the statute is trying to get at, is the reality of the fact that people have some expectation of privacy in information that they supply to something like an internet service provider. Now, as we've seen, it might not be the same expectation of privacy as we ordinarily have in our personal home and our personal effects and so on, but there's some expectation of privacy, right? But if it's not a provider of services to the public, like an ISP, then you really don't have an expectation of privacy. So what's an example of that? One example might be your employer. If your employer, if Seton Hall University keeps copies of my email on its own servers, not just on the servers of some ISP, I really don't have any expectation of privacy in that at all. And if the government asks Seton Hall for my emails relating to me, and Seton Hall wants to disclose it, they can under this statute. So another example, and it's referenced in the manual. If you're interested in all this, you can take a look at the manual. They use this one, which is a consulting company. So there are cases in which a private business, like a consulting company, might, as part of its consulting work, store emails or other electronic information on behalf of another company or another party or an individual. And again, that kind of stuff is, there's really no expectation of privacy. And now this, of course, doesn't mean that, if the government came to the Seton Hall University and said, we want any electronic information that you have on your servers about Opterbeck, doesn't mean they have to give it. They could still, refuse to give it without some kind of process. But if they want to cooperate and they want to give it, they can. All right, what else? There are other circumstances in which voluntary disclosure can be allowed regardless of this public-private distinction. And one really important one is consent. So if a disclosure is made with the consent of the sender, then it can be voluntarily made. And this can come into play when there are terms of service or terms of use that in which the provider says we may provide certain information to the government. That may well authorize certain providers to turn that information voluntarily over to the government, although a lot of providers are still going to require some kind of process in order to protect themselves. So this is these first couple paragraphs about consent. The third paragraph here talks about rendition of the service or protection of the property rights or property of the provider of that service. So if the service provider is being hacked itself and it's trying to investigate that hack, it might be able to disclose some of that information. The NCMEC, Center for Missing and Exploited Children, that's sort of a kind of heightened level, and that kind of disclosure can be made voluntarily. Inadvertently obtained by the service provider and relate to the commission of crime, relatively narrow category. And then the final category, in good faith, there's an emergency involving danger of death or serious physical injury. If there is a case of possible suicide, and a person sends an email or posts something to social media saying, I'm going to go jump off the bridge right now, that's where this provision will kick in. And if the government, if the authorities simply contact the provider and say, we've got information this person's going to commit suicide, we need to know who it is, you don't have to go through the trouble of getting a court order. So here is a chart drawn from the manual that I think is really helpful in kind of trying to parse some of this out if you're sort of faced with a problem like the one I'm going to give you for the skills exercise this week about what kind of notice you might require and what kind of process you might require. I'm gonna post these slides. You can also, if you download the manual, you can find this chart, and you can see it asks whether voluntary disclosure is allowed, if compelled disclosure is required, what kind of provider it is, and what kind of process is required.